All right. Good evening, everyone. Good evening. Tonight we are going to discuss a bankruptcy deletion. I'm going to share my screen with you all so that we can go over the bankruptcy guide. All right, let's see here. This ain't that updated. Let's see. Y'all, this is my first time using this little co-pilot thing, and this thing is all okay, here we go. It all looks a little different. All right, so I went ahead and shared my screen, so you all should be able to see me scrolling all the way back up to the top for this bankruptcy guide. It's a step-by-step guide to show you all how to delete your bankruptcy. You can have a chapter 7 or you can have a chapter 13. All right, so here we go. This is a practical guide for individuals and entrepreneurs who are trying to delete the bankruptcy from off your consumer reports. I always include my disclaimer. This just says that this guide is for educational purposes only and does not constitute legal advice. Bankruptcy laws vary by situation, and individuals should consult a qualified bankruptcy attorney to discuss their specific circumstances. All right, now let's start off with discussing what a bankruptcy is. A bankruptcy is a legal process under federal law that helps individuals and businesses who are unable to repay their debts. It provides either a discharge, which is elimination of certain debts, or a court-supervised repayment plan under legal protection. So a bankruptcy is governed by Title 11 of the United States Code and handled in United States Bankruptcy Court. It's going too fast. All right. So the purpose of the bankruptcy is to provide a fresh financial start, stop aggressive collection actions, and create a fair and orderly process for creditors and debtors. Bankruptcy is a financial tool, not a punishment. This thing jumps so fast. Not a punishment and not a failure. So what happens when you file for a bankruptcy, right? It's called the automatic stay. It's a moment because once a bankruptcy case is filed, an automatic stay goes into effect. This means the creditors have to immediately stop collecting calls and letters, lawsuits and judgment, wage garnishments, repossessions, and foreclosures, right? The automatic stay is one of the strongest consumer protections in U.S. law. Now, Chapter 7 bankruptcy. I'm going to describe both types of bankruptcies for you all. So the Chapter 7 bankruptcy is liquidation. This chapter is also called the liquidation bankruptcy, but most cases involve no liquidation at all. It eliminates most unsecured debts and typically lasts between 3 to 6 months, and is designed for individuals with low income or limited disposable income. Now, how does Chapter 7 works? So you're pretty much going to file a bankruptcy. You're going to do a bankruptcy petition. The petition is filed. A court-appointed trustee will review your case, and then most people keep all property due to the exemptions, which is the creditors, and then eligible debts are discharged. Now, the common debts that's discharged under the Chapter 7 is your credit card debt, medical bills, personal loans, or utility balances. Debts that's not usually included with the discharge for Chapter 7 is the student loans in most cases. However, we discussed student loans on yesterday, and I taught you all how to discharge your student loans through bankruptcy. Anywho, recent income taxes, child support and alimony, and your court fines and penalties. Now we're going to discuss the Chapter 13 bankruptcy. Now, Chapter 13 bankruptcy is a bankruptcy just pretty much for reorganization. Chapter 13 allows individuals with regular income to repay some or all of the debt over time. So with Chapter 13, you come up with a repayment plan that lasts 3 to 5 years. The debtor keeps all the property. So once you file the bankruptcy for Chapter 17, you're going to come up with a prepaid plan, and then you're going to pay all of that money back over 3 to 5 years. But the debtor or the debtor, we keep all the property. Remaining eligible debts are discharged at the end of the plan. So once you're done, making your payments through those 3 to 5 years, then all your debt will be paid off. How does Chapter 13 works? The debtor, which is us, we will propose a prepayment plan. The court will approve the plan, and then monthly payments are made to a trustee. The trustee pays the creditors according to the plan, which is the people who you are in debt with, and then the remaining eligible debt is discharged. Now, why do the people choose Chapter 13? To stop foreclosures and to catch up on mortgage arrears, to stop vehicle repossessions, to repay tax debt over time, protect non-exempt assets, and to handle large arrears in a structured way. Now, I created this chart so that you all can see a key differences within the Chapter 7 and the Chapter 13 bankruptcy. So with the Chapter 7 bankruptcy, it takes 3 to 6 months, and then a Chapter 13 is 3 to 5 years. Give me 1 second, guys. Make sure you won't go dead on me. There we go. All right, now, as far as the income requirements for Chapter 7, you must pass a means test. And then a Chapter 13, you have to have regular income that's required. And the only reason why in Chapter 7 you must pass a means test is because it's for people with low income or people that doesn't really have any income. So it has to be proven in order for you to get that Chapter 7. Now, as far as the debt repayment, on Chapter 7, there's no repayment plan because it gets discharged. But up under Chapter 13, there's a monthly repayment plan. As far as the asset protection, Chapter 7, it exempt assets only. And then Chapter 13, all your assets are protected under the bankruptcy. And then as far as the foreclosure help, Chapter 7 is something that's temporarily, and then Chapter 13 is a long-term solution. All right. Now, bankruptcy and credit, how long do it appears on your consumer reports? Chapter 10 can appear on it up to 10 years, and Chapter 13 up to 7 years if you allow it, which is the reason why I came up with this strategy to have the deletions of the bankruptcies. Now, important reality to everybody. Many people begin rebuilding credit within 12 to 24 months. Your bankruptcy often improves your credit health by eliminating debt, and your debt to income ratio improves immediately. All right. So for bankruptcy, for entrepreneurs and business owners, the bankruptcies can eliminate personal guarantees, stop businesses related lawsuits, allow restructuring while continue operations, and separate your personal and business liability. Business owners should always seek professional advice due to complexity. All right. Now, here are some key takeaways that you guys can take with you tonight before I give you the steps in the process of deleting the bankruptcy. The bankruptcy is a legal financial reset. Chapter 7 is debt elimination, and Chapter 13 is a structured repayment. The automatic stay provides immediate relief, and the goal is a fresh start, not punishment. Because a lot of people think that bankruptcies are some kind of like a bad thing. And yes, it does hit your consumer report hard when it is furnished on your consumer report. So I will throw that out there. But however, like I said, your bankruptcy can be deleted. Now, here's the do-it-yourself bankruptcy deletion guide. Right? Again, here's my disclaimer. This information is provided for educational purposes only and does not constitute legal advice. Credit reporting is governed by the Fair Credit Reporting Act, 15 U.S.C. 1681. Users are responsible for ensuring accuracy and compliance with the federal law. So, The strategy that I came up with is the clerk of court strategy. So basically, when you're deleting your bankruptcy, you want to send a letter off to your clerk of court, where you went through court with the bankruptcy, and you just gonna pretty much ask them, do they simply report to the consumer reporting agencies, simply because you want a certain response, and that response to be that no, they did not report to the consumer reporting agencies, because we're going to have a second letter to be sent out to the consumer reporting agencies, asking them what was their method of verification to verify that this bankruptcy is accurate. So here is a letter that you can actually send to the clerk of court when you went for your bankruptcy. So you're going to put your name, your address, city, state, and zip code, the dates of the actual letter. You're going to put the clerk of court of whatever, bank court that you went with, the district name, the court address, and then your bankruptcy court number. It just clearly says something very simple. It doesn't have to be anything wrong. It just says, dear clerk of court, I am writing to request clarification for my personal records. Thus, the United States Bankruptcy Court report bankruptcy information directly to consumer reporting agencies such as Experian, Equifax, and TransUnion. Thank you for your time. Sincerely, your name. So again, keep it very simple. We just need a very simple answer, okay? Now, you're going to be waiting for your response. Before I say that, please make sure that y'all are actually sending these letters certified. I send my letter certified just so that I can have records of myself that the letters were sent. And I also sometimes send the return receipt also to make sure that they sign, once they do receive the letter, that they sign off on it once they receive it. So I can have records of both ends, that that it was sent and that it was received, that they actually got the letters. Now, step 2, you're going to wait for the response from the clerk of court. Now, they're going to respond. They're going to say the court does not respond to the consumer reporting agencies, which they call the credit bureaus, but they're not credit bureaus people. They're consumer reporting agencies. The court does not furnish information to consumer reporting agencies, and the credit reporting agencies obtain public records through third-party vendors. Now, I do want to say this. The correct response that you want is it to say the court does not furnish information to consumer reporting agencies. You want that response because why? The consumer reporting agencies are going to say that they verified this with the courts. Now, in the meantime, when you send that letter off, you're also going to be disputing with the consumer reporting agencies as well. Now, you're going to be asking them for their method of verification, asking them, to investigate and to inform you of how they verify this information. So you're going to do this at the very same time. So you're going to create your letter for the clerk of court, and you're going to create your letter for the consumer reporting agencies, Experian, TransUnion, and Equifax. Okay. The clerk of court, you only need one letter because there is only one clerk of court that you did with your bankruptcy. And then as far as the consumer reporting agencies, being that there's 3 of them, you're going to send it to all. You're going to send that particular letter to all 3 of them for the consumer reporting agencies. This letter just strictly says, I am disputing the accuracy and variability of the bankruptcy information currently appearing on my credit report. Now, this particular letter, I would say you want to send after. Matter of fact, let me do the method of verification first, because I put that in last, y'all. I kind of mixed up the letters when I was putting everything together. I had the baby with me, so I kind of messed up with the packet, but I got to correct it. So this is the method of verification letter that you're going to send off first. Okay, it says, to whom it may concern, I am writing to request the method of verification regarding the bankruptcy information currently appearing on my consumer credit report, which you recently stated as verified. Okay, now y'all already know every time that we send a letter off to the consumer reporting agencies, they already say that they're verified, validated, or updated, and they do not verify nothing. All right, so I went ahead and threw that in there for them. So you're going to fill in your bankruptcy information. You're going to put, if it's a chapter 7, chapter 13, you're going to put your case number in, and you're going to put your court number in. All right. You're going to say, pursuant to the Fair Credit Reporting Act, 15 U.S.C. 1681 IA6B3, which is the method of verification, right? I am requesting disclosure of the method used to verify the accuracy and completeness of this bankruptcy reporting. Please provide the following: the name, address, and telephone number of the person, entity, or source contacted to verify the bankruptcy information, the specific documents, court records or data sources reviewed in your investigation. Confirmation of how you verified the filing date, your chapter type, case status, and any reported discharge date. Confirmation that the information reported reflects the official records of the United States Bankruptcy Court. A generic statement that the information was verified without identifying the source and documentation relied upon does not allow me to assess the accuracy or completeness of the reporting. Please note that merely repeating or parroting information obtained from a third-party vendor or automated database without independent review of official court records does not constitute a reasonable investigation under the Fair Credit Reporting Act. If you are unable to provide a complete and lawful method of verification, please correct or delete the bankruptcy information. Accordingly, please provide your response in writing. Thank you for your attention to this matter. Sincerely, and then your name. All right. So you're going to send that. And then, of course, they're going to write you back and say, oh, well, it was verified, right? So now you're going to send off the second letter responding back to them because they said that it was verified, and then you're going to attach a copy of the response from the bankruptcy court because you should have now received it, and you're going to put all of this together and you're going to mail it off to them because you're pretty much saying, I know that you did not verify through the court of court because I have reached out to them myself. And I attached the response from them telling me that they did not respond to the, report to the consumer reporting agencies. So please go ahead and delete this account. And then you also want to file a CFPB complaint, which is the Consumer Financial Protection Bureau, for a faster deletion. Now, here is the second letter that you're going to send out to the consumer reporting agencies. With the copy of the attachment from the actual bankruptcy court. So, to whom this may concern, I am disputing the accuracy and verifiability of the bankruptcy information currently appearing on my credit report. I contacted the clerk of the United States Bankruptcy Court regarding my case. The clerk confirmed that the court does not report bankruptcy information to consumer reporting agencies. Since the source of the public record does not furnish information to consumer reporting agencies, but I put credit bureaus, please explain how this information was verified as accurate. In the absence of direct verification from the court, this information is unverifiable under the Fair Credit Reporting Act 15 U.S.C. 1681 EB, because EB strictly says that they have to assure maximum possible accuracy of the accounts, all right? Please conduct a reasonable investigation and delete or correct the unverifiable information. Attached is correspondence from the clerk of court. Now, with this being said, y'all, it's nothing that they cannot do. They can no longer lie to you all that they verified it through the clerk of court, because we already proven the fact that they lied from the jump and said it was verified and it was not. So their only response would be to delete it. Okay, this is how you get a bankruptcy deleted from off your consumer report. So now that we know how to delete a bankruptcy from off your consumer reports, now for those of you who all have student loans that you was on our call yesterday, and I went over how to discharge your student loans through bankruptcy by also filing an additional adversary proceedings, which is a lawsuit for your servicer. Once you do complete that and everything is approved, bankruptcy and everything went through, once that bankruptcy gets furnished to your consumer report, you want to make sure that you come back here to get the bankruptcy deletion guide and delete your bankruptcy. Yes, I'm going to tell you that you're going to see a decrease that's in your score. However, remember the simple fact that you guys just did a whole discharge. So now you probably got 50, 60, or 70,000 or how much ever thousands of dollars deleted from off your consumer reports. You no longer have those negative information being furnished to your consumer reports. So me personally, I do not care if I will see a decrease in my score, because I'm also going to start to repair and rebuild, which means that you all now can have the ability and the chance to go ahead and to get you some credit cards, go ahead and get you some trade lines, go ahead and start building your consumer report, get that score back up. All right. Anyways, Also, if you guys need help, I do mentorship. My mentorship is only $5,000 in my group mentorship that I do every quarter. Now, if you need individual one-on-one and you need more time and you're not a person that work at a fast pace, I do one-on-one mentorships. Please just DM me, comment and say, I need one-on-one, or I need this letter. But I am going to drop the link to this do-it-yourself bankruptcy deletion guide so that you guys will be able to purchase it. It is now 7:20. I did not expect to have you guys on this call for long, but thank every single one of you who joined on tonight. Hopefully this is very helpful to you all to get these deleted. It's 2026. As I always say, we are not bringing any bad baggage from 2025 to 2026. You all have a good night.